You're on.
Good afternoon, everyone. Welcome to our town hall meeting. I'm going to give everyone just a few more or another minute here for everyone to get logged in, and then we'll go ahead and get started. Okay, I think everyone has joined in now, so let's go ahead and get started. I'm Nichole Segal. I'm going to be your moderator here today. I practice civil appeals here in West Palm Beach.
Nichole, your audio is not working. There.
Can you hear me? Okay. Okay, again, I think everyone has joined us. My name is Nichole Segal. I'm the moderator today. I work at Burlington and Rockenbach in West Palm Beach, and I do civil appeals. If you have any questions during the course of the program, please feel free to use the chat function at the bottom, and we'll try to get to your question during the program. The program provides one general CLE credit. I will give you the CLE course number at the end of the program, so be sure to have a pen or pencil and some paper handy. We have a great panel with us here today. We are pleased to have with us from the 4th District Court of Appeal, Chief Judge Spencer Levine, Judge Jeffrey Kuntz, and Clerk of the Court, Lon Weisblum. They're going to be discussing with us today how COVID-19 is affecting practice at the 4th DCA. I know we have lawyers from all over the state on this webinar today, and I think that the information discussed today is going to be helpful no matter what DCA you primarily practice at. I think we're all going to get some good information here today. Generally, give you an idea of what we're going to be talking about here today. We're going to talk a little bit generally about how the operations of the court and the clerk's office have changed in light of COVID-19 and some of the kind of big picture changes that have been made to how the court operates. And then we're going to discuss Zoom oral arguments more specifically. To our panelists, I'll be directing each question to one of you, but if any other member has, a thought on one of the questions, please feel free to jump in. I'm sure we'd all like to hear your thoughts on all these issues. We'll go ahead and get started. Judge Levine, what changes have been made as to how the court is operating as a result of COVID-19?
Well, first of all, thank you very much for the Palm Beach County Bar for inviting us to be part of this and to share information, because it's very important. One of the things of having this COVID-19 is the fact that we don't get to interact, and this is an opportunity for us to interact with the attorneys locally and throughout the state. Now, what we've done is very similar for other people from around the state to the other 4 DCAs. I can only speak for mine, but I know that they've been on top of things just like we have. For a few things we've done. We've limited access to the actual building, although through certain modifications, litigants have been able to access the building, to be able to file, but the public, in terms of their physicality coming into the building, has been limited. But I will say it's important to note that even though that we've had these type of modifications, we've remained accessible to the public, to pro se litigants, as well as to all the attorneys, and been able to be continued productive throughout. The specific things we've been doing is staff. We're very lucky that we have staff, great staff, but we also have the ability to work by telecommuting. Some of this being fortunate to be able to do this is by the fact that we've had prior experience in terms of circumstances like hurricanes. Being in Florida, you deal with that. So we were all literally within like a light switch. We're able to start transitioning to telecommuting. The court system was prepared. Believe it or not, we have this court system has a pandemic guide, and which all of the chiefs as well as the judges have been able to use. And of course, talking about the broad picture here, we instituted remote OA. I'm very proud to say we've never canceled OA. We canceled OA in person, but we allowed every panel to determine the parameters. We started off with telephone OA, which worked well. And we were able to, through the good work of the clerk's office and the marshal's office and all the IT staff who've done a phenomenal job, we were able to do transition to Zoom OA. So those are the few things that, as the last thing I'll say is that in the building we have some staff, but we have obviously only a few staff people. Most of the people are working remotely. And the last thing I'll say is that the two parts of the pandemic response was, one is to keep the courts open, to continue to be able to be accessible to litigants and to attorneys, and for the fact that our work went on seamlessly. And two, equally important, is to have our employees, attorneys who would interact with us, pro se litigants, for the safety of people. So we had a balance between, and that's the goals that came from the Chief Justice, is to keep the courts open, but at the same time, secure the safety of our employees and the people we deal with on a daily basis. So that's, I guess, a long answer to your question.
I think we got some good information. Lon, can you tell us a little bit about big picture, how the clerk's office is operating now and what changes were made?
Sure. And first of all, thank you for having me join you here today, and happy to kind of give you the status on what's going on with the clerk's office. First of all, I'm grateful to have such a wonderful staff, and I'm so proud of how they've worked together during these challenging times. In the clerk's office, we are operating at 100% capacity with a skeleton crew in the courthouse, with the remaining staff working remotely. And through the wonders of technology, we are just as efficient with our incoming and outgoing filings as we would be if everyone was working inside the courthouse. We're still accepting filings through the statewide portal, and we're still issuing outgoing documents through EDCA. And for self-represented parties, they can still come to the courthouse to file, but we're encouraging them to file through the statewide portal when they can, and offering them the ability to file by email if necessary, so they don't need to come down to the courthouse. But overall, it's worked out really well. The staff has done great and transitioned well to working remotely most of the time, and it's really worked out well, and our cases keep moving.
Good. I think you kind of just touched on this, but has there been any impact on the cases, either cases that were pending at the time of the shutdown or new cases being filed since, or sounds like everything's running, just the same?
Yeah, I'd say the existing cases are moving along very smoothly. We haven't seen many extension requests relating to the pandemic exclusively, and there haven't been any notable delays in receiving records from the county clerks. In terms of new cases, we've seen about maybe 1/3 fewer new cases coming in, and mostly those missing cases are in the areas of criminal judgment and sentence and criminal post-conviction. But again, going back to the existing cases, again, we're processing incoming filings very handily and issuing orders and opinions and mandates very readily as well. So all the existing cases, even if they've come in very recently, are moving along at a pretty good pace.
Great. That's great news for all of our clients.
I just jump in. I'd like to second what Lon says, that the clerk's office has just done an outstanding job. It is a very difficult situation to be able to to work remotely and still be productive. They have continued to be at maximum productivity, and we couldn't do it. The judges, all the judges of the 4th DCA, and I'm sure throughout the state, without outstanding staff like we have here at the clerk's office. So I want to publicly thank them for everything they've done.
Yes, thank you, Lon. Judge Kuntz, can you tell us a little bit from your perspective how the changes and how, the changes in operating have affected not only how you're doing your work and the other judges are kind of doing your daily work, how you're deciding cases? How does it affect your daily life?
I think the end result probably, is no different in terms of when we meet, but I do think that we've all used different technologies that we hadn't used before. I actually think I might be meeting more in person via Zoom or Microsoft, well, not really, via Microsoft Teams or FaceTime or phone calls with other judges on things such as motions that, we could have emailed in the past, or, but now we're more likely now, maybe because people are getting more familiar with it, that we're getting on, I think, Teams probably most frequently, at least in my experience, and having video calls. Maybe if I'm sitting in my office at the courthouse and somebody else is sitting in their desk at home. So I think that's been interesting to me to see it evolve from at the beginning of this process. People were maybe a little hesitant to jump on Microsoft Teams or things like that. And now it's, oh, this motion just came in, let's jump on Teams in 30 minutes and have a video chat about it. But overall, the conferencing is exactly the same. It's much like this on the screen. We'd have the 3 judges there, or we'd be on the phone and talking about it just as we always would. So I think the actual discussion process is no different, other than now we're looking at each other on a screen. Although when we're doing those, we wouldn't have the identical background. So, but we say what we have to say, and everyone says whatever they have to say about that issue, and we move on. So the actual conferencing of cases, deciding of cases, I think is very similar. We're just doing it in a very different way now.
Okay, great. I guess we'll move on to, I think, just Zoom oral arguments. It's something we've touched on a little. It's been one of the major changes. I think from a practitioner standpoint, this is the biggest change in what we're doing, obviously. Our briefs are still kind of getting done, and that work's getting done the same, but this is kind of a whole new world with lots of new considerations. So I'm excited to hear from you all a little bit about that. Lon, I want to start out with you, and I think Judge Levine may have touched on it a little earlier, but can you tell us, are all cases now being set via Zoom? There's still an option to do telephone? Let us know where we're at as far as how cases are getting set for oral argument.
The way it's been working is that in most cases, the panel issues an order saying that the in-person oral argument is canceled, and tells the parties that the oral argument will be held by Zoom unless the parties file a stipulation to opt out of it. We've had a couple cases where the panel has said, no matter what the oral argument's going to be going forward, but basically either way it comes in the form of an order. And I don't know if the Chief or Judge Kuntz want to add to that, but that's generally what's been happening. Okay.
Judge Kuntz, Lon just mentioned, you could get the option to cancel an oral argument or to hold it, to decide if both sides, I guess, agree to not go forward. What are your thoughts on that? If you get a call from opposing counsel who's interested in canceling, do you think it's worth canceling, or do you think that this is a forum worth moving forward with?
I think from our perspective, the reason we're giving the option is it's totally up to the attorneys that, some people are comfortable with Zoom, some people aren't, some people are comfortable with technology, some people aren't. Maybe both parties agree that something's changed in the world or in the legal world, case law or something, that maybe OA is more necessary or less necessary. But those are all factors for the attorneys, and that's why we're giving the option. And I've been on panels, I think definitely panels with Judge Levine, where we've had people agree to do Zoom and also agree to opt out and just not have oral argument. And, we're giving that option so that you can either have Zoom now or have the case conference without oral argument, Zoom oral argument now, but so the case isn't delayed. But I think whatever the resolution is, it's not going to affect how we think of the case. We didn't when we had cases opt out, we didn't treat it any differently. We still prepared the same way. We still conferenced the same way and discussed it. I guess having seen both, the one thing I haven't seen, and I think fortunately, is cases where people fight or file motions saying, you know, I don't think it's necessary anymore. This other person does, you know. So to the credit of the lawyers have been able to agree whether that agree it's not necessary or agree that it is. And maybe in those cases they don't originally agree and they find a compromise. But I think it's worked well. But from our perspective, we're not going to treat it any differently. It's not going to impact the result one bit. Of course, the only difference is there won't be oral argument, but we're gonna treat it the same way and prepare the same way. So people shouldn't feel like they have to have it or that they have to opt out. We're not factoring that decision into anything.
I think that originally people were requesting oral argument when it was in person, and when the whole world changed and transitioned overnight to remote means, we wanted to give people an opportunity to make that determination. Now that it's sort of become part of the fabric, I think that we still allow, as Judge Kuntz rightly points out, some people are comfortable with it, some aren't. But I would say that if you felt that you should have oral argument in person, you should feel equally strong about having oral argument on Zoom. I don't think that, and we can discuss that later about the difference, but I don't think substantively, if you felt that you wanted to have OA, then it's really, you shouldn't be dissuaded by the fact that the medium has changed, because there may be advantages in the medium, and that it certainly wouldn't put you in any worse position. So I concur with Judge Kuntz.
Okay, great. Just a reminder to all of our participants or attendees, if you have any questions, you can use the chat function, and I'm going to keep my eye on that as we go through here. But my next question is for Lon. What is the court staff doing behind the scenes to ensure a successful Zoom oral argument session?
Well, it's quite a bit, and it begins a few weeks before the actual session. After we know which cases will proceed by video, my calendar clerk contacts all the attorneys to find out who will be arguing. And then in advance of the session, myself and my IT staff schedule separate test sessions with the panel and the attorneys. So we participate in those sessions, make sure all is looking good with the attorneys. And then the IT staff schedule the actual OA session. We provide the login information to the panel and to the attorneys. And then on the day of oral argument, we actually have 3 people in the courtroom: an IT person to run the Zoom meeting, a member of the marshal staff to run the time clock, and then the marshal to call court. Outside the courtroom, another IT person plus myself are watching the live stream on the court's website in case there are any problems. And I'm also in touch with the IT person running the Zoom meeting, just in case we need to contact one of the attorneys, which is sometimes necessary to address any connection problems that they might have. So it's a lot of people involved, and we work together to ensure that the panel and the attorneys have a successful session. And ultimately, what we want to be able to do is, when the oral argument starts, we want the panel and the attorneys just to be worried about the oral argument and not anything related to the different avenue or technical means by which we're doing the oral argument. So it's a lot of people doing a lot of things behind the scenes to make it all happen.
And Lon, and can I add, and correct me if I'm wrong, but logistically and behind the scenes, the original notice of oral argument that's going out in most cases still says it'll be in person, I believe, or at least it did for a while. And then as it gets closer, that's when, you know, I think you said your staff at some point will call the attorneys in advance. Around that time, we're issuing a new order, correct? Canceling oral argument and asking around if they want to agree to Zoom or no Zoom.
Right, that's
correct. I
correct.
think that's one of the questions in the chat as well, I believe,
Yeah.
some along those lines.
Yeah, what we do is that the oral argument is set, the initial order sets it in the courthouse, and then closer to the time of the oral argument, when the panel gives the go-ahead, we'll issue the order basically canceling the in-person argument, offering the opt-out with a deadline, and then once that deadline passes is when we start the process of reaching out to the attorneys and scheduling all the Zoom tests with the panel and with the attorneys.
And I think we have a question on the chat, which I think kind of goes along the lines of what you just mentioned. And this also gets into a little bit, I guess, about what's going to happen in the future, which we'll talk about. But from Andrew Harris wants to know, he has a July oral argument set, and the notices state that they will be in person, subject to change. Assuming the court decides to open that day and to actually hold oral argument that day, will the attorneys be allowed to appear by Zoom if they aren't personally comfortable in the courthouse by July? Let's say, using that as an example. If the court decides we're open for business, we're going to have OAs here, but if any specific attorney is not comfortable with that, are there going to be options? Have you all thought of that?
Well, let me just take a stab at that. I think that I don't want to give anybody full solutions. Let me talk from 30,000 feet. We are, the Chief Justice has put on accessible to the public sort of broad range phases of getting back to a modicum of to where we're back to business as usual. We are transitioning right now from what they would call phase 1 to phase 2. Phase 1 is where we're pretty much, as I said, limited access. Phase 2 allows staff a little bit more access, but once again, with the understanding that the safety and security of employees is paramount. Under phase 2, there would be no in-court OA. Once we get to a phase 3, hypothetically, it could allow in-court OA, but then having live streaming, and therefore the public would have immediate access through the internet, like we do now. So, as much as we'd like to tell you and prognosticate the future, whether it's a July OA or a September OA or an October OA, we just don't know the future. We are going day by day. We are doing this with the understanding of understanding the big guidelines that are coming from Tallahassee, who have a big job. And I'd be remiss not to say that as important as our job is, as important as the Court of Appeal is, that the trial courts are first and foremost a high priority for the court administration to be able to deal with. So we're part of a bigger issue, so whether or not there'll be in-court OA and whether or not those are bigger issues that we cannot prognosticate. I think that we're going to proceed cautiously, proceed with the understanding of being maximum concern for our staff and for you and the attorneys. Those are things that will have to be dealt with when we deal with it. But when we get to a phase 3, where it's in court, then hypothetically, and this has not been decided, but this could be a potential for remote access, perhaps, and perhaps not. But remember, oral argument is discretionary, and nobody has to request it. And as Judge Kuntz rightly points out, whether we have OA or not, your case will be decided and will be decided with the same seriousness of purpose. So that, I wish I could give more definitive, but the good news is we've proceeded a long way in a short period of time, and we're hopeful that we'll be, as time goes on, we'll be closer to phase 4, which is pretty much pre-COVID-19.
Thank you. We'll go back. Lon, what are the biggest technical issues you have seen when running Zoom test sessions with the attorneys so far?
Well, fortunately, we haven't seen many, and actually what I'm about to say somewhat responds to Brian's question in the chat, which is a very good one. Perhaps the biggest issue we've seen with the attorneys in the test sessions is where the attorney tried to do something other than sitting in front of a computer and using a webcam. For example, trying to stand behind a podium or using a very large screen. In both of those scenarios, it caused the attorney to be too far from the camera and the microphone, where it was difficult to hear them and see their face. So my advice to anybody who's wondering, well, what's the best setup is don't overthink it, because the most important thing is for the judges to see you, hear you, and have no distractions. So kind of like you see me and Judge Kuntz and Chief Judge Levine right now, is that we all have a neutral background behind us. You can see basically us from shoulders up. There's no other distractions on the screen, and that's really the best way for the judges to be able to see you. And where we've seen more issues is that when somebody has kind of stepped away from that. So hopefully that clues you into the bigger technical issues that we've seen. And Brian, hopefully that answers your question a little bit too.
All right, thank you. Judge Kuntz, do you have any general Zoom technology advice for the lawyer from your perspective as a judge? And I'll just add on, as we've, Lon just touched upon it, but if you could also, as part of this, address background, no background, something plain. If you use a background, what kind of thoughts do you have on that, the technology side there?
Well, of course, I agree with everything Lon said, but I think the most important thing, and I guess this applies whether we're Zoom or in person or wherever we are, but practice, set it up in advance, do all the logistics, talk, have a Zoom call with a friend or a colleague, but I would prepare a space and test it. For example, when we weren't allowed to be here in the courthouse for a little bit, I had Zoom at home, but then when that changed and I was coming in just for Zoom OA, I came in just for the Zoom practice OA, so I could set up the desk, set up everything, set up the background, and make sure that when I did come in for the actual oral argument, everything was ready. But things like, are you going to use a microphone? I'm using a microphone. Are you going to have headphones? Are you going to have backup headphones in case something goes wrong? I do think positioning yourself, when I was doing it at home where are the lights? Where's the sun? Because at times it is hard for people to see you. I mean, I know Judge Warner, during our first Zoom practice session, I was significantly better the second one, because the first time she said she could barely see me because of just the way the sun was behind me. So I turned my desk around. So I think things like that, but set it up, practice with it, do a test Zoom call, and then do it again the morning of the oral argument, just to make sure, if there's someone else that might have moved a court around or something. But in terms of going back to Brian's question, I think sitting is best, because unlike a real oral argument in the courtroom here, you have the advantage of you can be sitting at a desk and you could have things that we can't see. You could have, some notes over here. You shouldn't be reading from them, of course, because you don't know the questions they're going to be asked, but the key points or record pages that you think you might need to reference, or cases that you might, so you can, if you're sitting down, you have a whole desk that you could have things on there that might help you that we will never know are there. So I think sitting down, but going back to what Lon said, it definitely works better when you're closer to the computer, because if something goes wrong, it's a lot harder to fix it. We can't hear you as well, we can't see you as well, but then if something goes wrong and all of a sudden the computer starts doing something, you're not near the computer. Instead, you're staring at a TV screen. And it's just much harder to change the settings in that situation. But so I think practice is the big key there. And as to backgrounds, we're not going to, some people can't use, we have, depending on the computer that you have, some computers, including relatively new computers, cannot use Zoom virtual backgrounds. So that's completely understandable. But I do think having a plain type background, something that doesn't stand out, we've seen people, using, I have not seen, but you can read about, people using, in their bathroom or in their bedroom, which can be fine, but you might want to turn it so it's showing the wall instead of other things. You don't want it to be in a public place where a lot of people are going to walk behind you. One thing that I know did happen at a hearing, if you're using your Zoom to have that virtual birthday party the night before and you have a different background that might not be quite as appropriate, make sure you have the preview background button checked. So when you sign on the next morning for oral argument, you don't have that background that is probably not as appropriate for the court setting and maybe is more best for just your friends. And I know that I heard that did happen as well. So I think be prepared. And also things are going to happen. If you do all those things to prepare, something could go wrong. We know that. Go with the flow. it, you know, there's people that have been completely prepared, have gone to all the lawyers that have gone to the training sessions just the morning of, all of a sudden it's not working quite as well. So I think, you know, don't stress out if you've done all those things and something still goes wrong.
Okay, thank you. Judge Levine, how is OA different from your perspective of a judge by using Zoom? Do you find any differences between the live, or what are your thoughts?
Yeah, I mean, that is a work in progress, and we're still, but at my initial reactions, I think substantively, it hasn't made a difference. I mean, the cases are pretty much, now, so first of all, and I think just sort of dovetails into the question about, that we just dealt with, which is the practice sessions and all that. So initially, a Zoom OA becomes, the technology becomes centerpiece as opposed to the substance. So the more practice you have, the more that it becomes second nature, then you have the ability to sort of transport yourself into the courtroom. Then we're talking about the case, and we're not really worrying about, can they hear me? Can they see me? My distractions. What if I've seen, you know, sometimes you get feedback. Sometimes it's the sound is not as clear, or you hear that echo effect. So those things become, so to the extent that we do that type of practice sessions, and you do those practice sessions, you know, although nothing's foolproof, it tends to become lesser and lesser as you get used to it. So therefore, the technology becomes more commonplace, just like everything else. And therefore, you can, when I start as the presiding, I have to go through a litany of issues with the attorneys, you know, gallery view, whether or not, if one of the judges gets cut off, just keep going, don't stop. And that judge will listen to the OA later before we conference it. So there's a litany of technical issues that we presuppose, but most of the time it doesn't happen. So once the technology becomes a second issue, then the substance becomes, I think, the number one thing. I think that's the sort of observation is that because of the technology and because there could be a delay in my speaking and you hearing me, therefore, I think I tend to find that people listen more because I'm waiting for you to finish your sentence. And so that may be an advantage to the attorneys. The disadvantages could be that sometimes a robust discussion back and forth illuminates the issues and is better for the judges. And obviously the whole purpose of OA is for, you want all the questions the judges have to come percolating out, because you don't want them to walk out not having their questions answered, because that answered question could behoove your side. So I think that is something that we have to be mindful of, that we listen, but yet not hold back. So, and then the other thing is, there is, I think, a more of a concern of that, like I said, of that technology, and whether or not that's going to hold you back from having the same type of forceful argument you would have in the courtroom. I would definitely implore you not to argue it any differently than you would if you were in the courtroom. I know it's easier said than done, but you know, trust me, we are used to the Zoom now, because we have been in OA before through Zoom, or we've watched other people in Zoom, or we have practice sessions which are open to all the judges. And I have done that as a way of really getting used to it. So, all right, so another way to answer that question too. So I think that to the extent that technology becomes lesser an issue, I think the difference between becomes almost none. So I think there are real advantages to it, and but especially for the presiding judge, there is, like in the courtroom, there's a responsibility for keeping order and keeping it moving and what have you. And I think the Zoom adds a new layer of issues that the presiding has to deal with. But that aside, I have found that the more I do it, the more that it's just like in the courtroom. Of course, if you have a technical problem that day, then it becomes an issue. But anyway, so that's another short answer.
Thank you. Judge Kuntz, I'm going to follow up a little bit on what Judge Levine, I think, just touched on a little in his answers. Do you have any advice for the lawyers in the actual argument, in a Zoom argument, that would be different, in how they argue or how they're kind of presenting their case to you all?
I guess the first thing I would say is keep in mind that, when we do it, it's in gallery view, so there's a time clock, 2 lawyers and 3 judges on the screen, but you're always on the screen. So keep in mind that, the eye roll or the shaking of the head, somebody's always going to see it, as opposed to the courtroom where, maybe get away with it sometimes. But so somebody's going to see it the other side. And, so keep things like that in mind. But just in terms of preparing, I have noticed that I think, as Judge Levine touched on, I think there's been a tendency to let people talk a little more before the panel starts asking questions. Not in every case, not every panel, but I've sat 3. I did 1 telephonic panel and I've done 3 Zoom panels so far. And I think the initial argument, so in the courtroom, when I was a lawyer, I always assumed that I would be interrupted before I got my last name out. But I've seen a couple times where the lawyers, have gone a couple of minutes of arguing before any judge says anything, and more so than in the courtroom. So I would be prepared, not necessarily with a speech, but, with an outline of what you might say if it is a quieter bench, at least at the start. And then, as I said, you can have your notes all spread out on all the different issues, so that if the panel wants to focus on one thing, you could, we wouldn't even know, but, you pull up those notes right in front of you, those record pages, those transcript pages. Because it does seem to me like we've been getting a lot more specific, on page 3,796 of the record, you'll see this, and then they'll jump right to something else. So, it seems like maybe it's a little easier to pull those things up in front of you. But just generally, again, I think preparation is the big key. Do it as many times as you can. You can definitely tell if you had watched the collective group of judges in our first practice session until I think every judge has had at least 1 panel so far, but you will see that the judges are much more comfortable, and that's only because we've done it a number of times, as Judge Levine said, that, as with anything, you're going to get comfortable. So do it a lot, and then treat it just like an in-person oral argument, because we're preparing the same way, we're doing the same things, and the only difference is we're not walking into the courtroom together, but we are, doing everything else the same. So I think the lawyers should treat it the same way, but at the same time, like I said before, prepare with the technology and then be understanding if the other side has a problem, because, they're going to be stressed out about it just as you would be if you were all of a sudden your audio wasn't working. And I think that's happened once or twice where, for whatever reason, it worked the day before in the practice session, but an attorney, you were unable to hear them, or, it just, something went wrong. So, be patient.
And that leads right into my next question. Judge Kuntz, I'll stay with you. So what should you do if you're a lawyer and you're in the middle of your argument and there's some sort of technological problem comes up, either on your end or maybe one of the judges?
I think if it's one of the judges, you don't worry. You just keep going. And, that's actually happened. We've had a judge whose computer overheated. We've had a judge who had internet issues, or I assume that was the issue. And, there are 3 judges up there, and it's being recorded. So that judge will go back and watch whatever they missed. But to stop the argument for that judge, it's not feasible. At the same time, if you see opposing counsel's video fall off, usually the presiding judge will have noticed that as well. But if not for that, you should stop, because we wouldn't want to continue without the 2 lawyers being there. And if it happens to you, this goes back to the, don't stress, calm down. We have our amazing IT staff that works for Lon. You know, they are watching to make sure if something happens in advance, they'll have your cell phone number. They will try to help you work through it. They'll try to, you know, I think the biggest thing is not really a big technological issue, is people forget to put it on mute when the other side starts arguing. Well, fortunately, the IT staff is able to mute it for you. But, you know, things like that. So they'll help you through it. But if you were to just get completely knocked off, that's why we get the cell phone number in advance of the arguing attorney. And I don't know, my guess is it would be Lon that would be calling you in that situation, and, you know, telling you to calm down, and he would help you work through it. But again, don't stress, because we'll have stopped. We won't be doing anything. You know, we'll be waiting for you. And, you know, we know those things happen.
And we'll give you the time back.
Yes.
Okay, thank you. So Lon, we'll jump to you on that end. What do you do on your end? You're monitoring, I think you said earlier, you've got your staff there. So hopefully if you had issues where you weren't able to get someone connected right away, or what happens if we just can't get back on today?
Well, what we would do is that if all else fails, there is a call-in number, and we'd have the person call in if that's what the panel would do. But so far, anytime we've had an issue, we had somebody with an audio issue. Once we had them mute themselves and unmute themselves, and all of a sudden it worked. We had another one with some feedback in the background, and we actually stopped the oral argument, and the judges left the virtual meeting. We called that attorney. We gave them instructions on how to fix it, and then we got that going, and then we proceeded with the oral argument. So we've got a few different troubleshooting things that we can do, and if all else fails, there's the ability to have someone call into the Zoom meeting, as just no different than a few of you have called into this Zoom meeting.
Okay. So the takeaway for us lawyers is to don't stress, although I think that's easier said than done.
Well, and we're aware that it will be stressful, even though I can say don't stress. It would be stressful.
Thank you. All right, Lon, there are, and we've seen a lot of news, I think, especially back when people were first starting Zoom, although I think maybe not as much now. How would you respond to an attorney who's worried about the security of having an OA on Zoom?
And I get this question about once a week. So what I tell them is that to the extent they've read in the media about security concerns with Zoom, those concerns have arisen because the host of the Zoom meeting wasn't using best practices for security. And some of those things include implementing unique meeting IDs and passwords, and not putting the Zoom meeting information out to the world. So without getting into everything that we've implemented here at the court, I can tell you that before we even attempted to test an oral argument with Zoom, we went through all the possible security settings, locked everything down, and it's been very successful for us. So really it's about that work you do in advance to make sure everything is locked down and secure, and also not just sending out that meeting information to the general public. But you know, the good news is that as many articles you might see out there about issues with Zoom, now you have a lot of information out there about Zoom security. So we make sure we implement all those best practices.
And one other thing on that is, unlike a lawyer maybe talking to their client, when we're broadcasting an oral argument, we're broadcasting it to the public anyways on YouTube and on our website. So it's part of the security aspect is not as much of a concern for us, because if somebody wanted to steal the feed of the oral argument, well, we're giving it to them anyways.
Okay, good point. Thank you both. We're going to move on a little bit, I guess, on where we go from here. Judge Levine, I know we did talk a little bit about this earlier. It came up with one of the questions, but any other potential next steps for the court in the future, other than what you've discussed, kind of following the court's phased or the phased opening? What else can you say about that?
Well, I mean, in terms of the openings of the court, there is a work group that is sponsored by state court administrators under the Chief Justice's rubric, and they are crafting for all the issues of it's a statewide group, and they are determining trial courts and appellate courts and how we can do this quickly but safely. From the appellate court's perspective, we are right now transitioning from phase 1 to phase 2, which allows our employees to come in the building with a little bit more frequency, but still we are stressing remote access for things that should be done remotely. We'll have minor differences, like for example, judges can now work in chambers as opposed to only working at home. Phase 3 will be, there'll be criteria and guidelines that are going to be designed by the work group and accepted by the Chief Justice and OSCA, State Court Administrator. And once those are designed and deemed approved, then those would be, we would hope to move to that. And with the understanding also that phase 4 would be potentially pretty much pre-COVID-19. I think that the question about phase 4 is how many things that we've done through this circumstance will last into some of them will have to be considered once the administrative orders that have allowed this sort of flexibility. Will there be rule changes? Will there be administrative orders? Will there be rules of judicial administration? These are things yet to be determined, but I think I'd be surprised if they weren't going to get a critical and a look at. And, I think that a Zoom type remote access has shown itself to be to have some staying power, and perhaps will be able to be even post COVID-19, but stay tuned.
All right, thank you. Does anyone else in our panel have any, those are all the questions I have. Does anybody else have any final words? We'll start with you, Chief Judge Levine.
Well, I want to once again thank the Palm Beach County Bar for having this. It's really important to be able to, I would assume that a lot of the people, participants are stakeholders who are the people who come in and a lot, or people who are just really concerned about the court system in general. So I thank them for participating. I thank them for listening to us. I think that I will leave you with that we are totally committed to the safety of our employees, the safety of the attorneys that we interact with, as well as the litigants. But at the same time, I will say, and to proudly, that we are working with total productivity. Now, I will say that it's lucky. We're lucky. We are. I wouldn't say lucky, but the job entails it's easier for us. Our friends, our colleagues in trial court have much harder to deal with, and for that, a lot of the effort needs to be geared to that. Our work is effortless to be able to transition, so that's why we're able to do it very quickly with maximum efficiency. Having said that, it's not, I have to once again applaud all the employees of the 4th DCA, as well as the other DCAs statewide, because they're working at the same maximum efficiency, and it's not easy to work from home. It's not easy, and for that I am very appreciative. So thank you again for inviting us, and we look forward to seeing you hopefully in the near future at our courthouse.
Thank you. Any final thoughts from you, Judge Kuntz?
No, just thank you very much for having us, and I'll leave it with what Judge Levine said.
All right, Lon, anything from you?
No, I just want to say thank you for having me. It was great to talk to everybody and see everybody, albeit virtually.
Okay, it's good seeing you all too. Thank you. Well, this ends our program. I want to thank all of our guests for taking the time to be with us today. Be sure to enter in or apply for your CLE credits on the Florida Bar page. If you've got your pen or pencil handy, I'll go ahead and give you that number. The title is How COVID-19 is Affecting Practice at the 4th DCA, and the CLE course number is 200-2973N as in Nancy. Again, it's 200-2973N. Again, thank you all for participating, and thank you for everybody for attending and watching. And thanks to the bar for setting up such a great program for us.